Only with, sorry, Mr. Mjapel, of dealing only with what?
The profits.
Oh, yes, okay.
Yes. Yes. If the tribunal is so inclined, we make that provision in paragraph 5, that 5.1, that they file with the tribunal within 30 days an audited statement of expenses incurred, the income received, and the net profit it would have made under the disputed tender or services contract. And then that the department, the third respondent, and or the SIU must, within 30 days thereafter, obtain an independent audited verification of details provided by the first and second respondent and file an audited verification with the tribunal. Alternatively, the parties can conduct a debatement exercise to determine all the monies received from the third respondent in respect of the disputed tender or the extension thereof, except the actual reasonable lawful out-of-pocket expenses, and the first respondent may be able to prove that it is incurred in rendering the service.
Mr. Mjapel, practically, how will that work? Who's going to be to police that, to see that this is done? But you're still going to come back to the tribunal?
Yes, practically, the respondent will file audited statement, and the applicant will look at the audited statement and verify them. We have made provision where to do a debatement, and if we not agree, then there will definitely be a special. There will be a special hearing specifically dealing with the documents that have been received, dealing with those calculations. Yes, yeah, that is how it's done. Yes. Right. Yes, and the cost, I'm sure even MEC will agree that given the volume and the complexity of this matter, cost of two counsel are justified. And I'm told now that there is I must mention a scale. It must be the highest scale, which I believe is scale C. So if the order is in our favor, we'll submit that cost of two counsel are justified at the higher scale. And
one last A, B, C, why C?
Yes,
because B is equally punitive, I think, to some extent. But C is almost, well, still far from attorney-client, but is fairly high.
It's fairly high.
Yes. What I'm saying, you must give more meat, I think, for C.
Without running away from your question, my lord, I'll say it's in your discretion. But I wanted to say something that might tie up with what I'm saying.
Yes.
Yes. The SIU is in the department, but the department has chosen not to participate. They are enjoined by law to protect public funds. When they do an exercise like this, the applicant, when they come to court doing an exercise like this, they are protecting the public purse. If by somehow it is found that they are not successful, it will be my submission that the tribunal should have that in its mind to say this public entity has got a statutory duty. The department has got a statutory and constitutional duty to take care of public funds. They chose to come to the tribunal and give the tribunal the investigations. If they fail, they should not be punished with costs. Those are my submissions. If we fail, there should not be any cost order granted against the applicant.
Well, isn't that what Ms. Killen is saying, that it's very difficult where you've got a third respondent, but it doesn't have an answering affidavit. And some of the things, but anyway, let's wait until she she tells us,
Yes.
or she presents her argument, because
Yes.
I think her argument is that some of the transgressions are not necessarily due to her client, but the department alone knows what happened. All right.
Yes.
Let's leave it there. Yes.
Yes. No,
Let's
I
leave
hear
it there.
that.
You still have a second bite on this.
Yes.
Carry on.
Yes. No, I've concluded, except that if there's any other issues that come from the bench, from the tribunal, any questions, those are our submissions in chief.
But no, I think I will have a better perspective once both of you have presented. So yes, don't worry. Thank you very much, Mr. Mjapedu. Your presentation was quite coherent. Shall I move to Ms. Killian? Are you happy?
As it pleases you, my lord.
Thank you. Ms. Killian, please.
Thank you, my lord. I very briefly would like to visit the question of the review powers of this tribunal, simply because it flows into my argument at a later stage. Therefore, cognizance must be taken of Section 8 sub 2 in terms of the SIU and Special Tribunals Act, which confers jurisdiction. It does not give the legal basis on which the review is taking place. In order to ascertain what that legal basis is, one has to ask the question, because case law says a decision of a state organ doesn't fall into parja, one has to look at a simple legality review. And this is the approach that has been followed by a number of cases. Now, the question with the review is, was this public power, was it exercised to comply with the Constitution? That's the very nub of the inquiry when we say we submit to a legality review. And the case law is clear on that, which are to be found in my heads of argument. Once we understand that the application of sections 172 and 217 of the Constitution governs this review, and having that in mind, one then can start asking, what are the irregularities? My learned friend has gone to the trouble in his heads of argument in demarcating each category of irregularity, and I will follow his submissions to say whether these complaints, if I can put it that way, can be elevated to and equaled to an irregularity that needs to be reviewed. So my approach would be looking at each one of the categories and the end thereof, say, to the tribunal, the applicant has succeeded in showing an irregularity or not, and whether it is only a transgression that should be lied to in front of the door of the third respondent. But before that seriatim or individual approach is followed, there are two facts that must be borne in mind throughout the submissions that I'm making with respect. There is a must remedy and there is a may remedy. The must part lies with the power of a court, which is this tribunal, in the extent that it's got review powers conferred on it, that if there is proof that certain conduct is invalid and offensive and inconsistent.
Wait, what happened? Oops. Ms. Killian? Mr. Mjapedu?
Yes, she seems to be frozen, Judge.
Oh, she's frozen.
Yeah, her picture is frozen.
Okay. Ms. Killian, we can't hear you. Anyone in Ms. Killian's team, just advise her that she's frozen. Maybe she needs to terminate and come back. She's still there, hey? Mr. Chilwan?
Yes, Judge, she's still on the screen. However, it's frozen.
Frozen, okay.
I'll call one of her team members now.
Oh, is he still talking? Or so one of them must be aware. She left the call. Someone called Natasha. Okay, but if you can, please, Mr. Mjapin.
Judge, I've just spoken to Advocate Fig, the junior.
Yes, I can hear you, sure.
Yes, she tells me that they have a connectivity problem in chambers. Apparently, is the whole chambers, and they requested a stand down of 5 minutes. As they
that's fine.
Yes,
that's fine. No, I understand.
Thank
so
you.
I'll continue to mute then. So
Okay,
please don't say, don't scan her because I'll be hearing you.
Okay, thank you. Thank you for the warning, Judge.
All right.
Yeah, I've asked the judge for 5 minutes, ne?
Thank you. We've got all the problems you can imagine in Johannesburg today.
Oh, yeah. No, we are fine today. Today's our day.
Let's see.
But are you fine?
Yeah, we are now good. It's they've been working on replacing the whole network here. So we came in on a day that there's a changing from one to another network.
Oh, no. So
but they told us the old one is still okay. So let's see how long that lasts.
Okay. Okay. Yeah, because I've asked for 5 minutes. I see the judge's chair is empty. Oh, it's back.
Thank you. Thank you, my lord. We have all the woes and difficulties in Johannesburg today, but back online.
Just I'm coming back. Say thanks is not load shedding, Miss Killian.
Yeah, that would
something else, I'm sure.
that would complicate matters. I am grateful.
All right. You can you may carry on, please.
My lord, just for completeness sake, I will maybe rewind a little bit and ask the question: what are the irregularities relied on?
Just a second. What? I believe my camera is off. Just a minute.
That's correct.
Yeah, it's on now. Thanks.
Thank you,
Yes. Yes.
I'll start with the question: what are the irregularities that are relied on by the applicant? But before we look at them seriatim, I submit the two legs of what Section 172 of the Constitution enjoins a reviewing authority is, firstly, to ascertain whether the applicant has proved that these irregularities are of such a nature that they offend against the principle of legality that is envisaged in the Constitution. That's the first question. And once that is established, that then doesn't give any maneuvering space. The tribunal must then declare that conduct void. or the contract that flows from it void. However, it must be read with the second part of section 172, which is sub 1b, that the court may. Now, the may is where the discretion lies. And then we start asking, what is the remedy for the fact that there is now a declaration of voidness of conduct or a bid or a contract? Now, if one follows the inquiry into the legality of the process that the government should follow in terms of procurement, the next guideline sits in the Constitution with section 217, my learned friend referred the tribunal there. And there are very clear indicators. How must this irregularity be assessed? Was the contract for goods or services in accordance with a fair system, transparent, competitive, and cost-effective system? Those are the guidelines that must be followed. Now, the assessment is done in terms of the powers bestowed on this tribunal, read with 172. However, there's a rider that at this very stage, even before we discuss the different irregularities or alleged irregularities, must be borne in mind. And that is that the section or the part that empowers the court and enjoins the court to set aside, there's a rider to it. If I can read then 172 sub 1 with the necessary emphasis. Mm-hmm. When deciding a constitutional matter within its power, a court, sub A, must declare that any law or conduct that is inconsistent with the Constitution is invalid. Now I'm giving emphasis to the extent of its inconsistency. That is a part of the inquiry that should not be disregarded, because from the outset, I want to remind this tribunal that it is in order to do a partial declaration of voidness in as far as this particular bid is concerned, because it has two separate bids rolled in one. The fact that it was treated as one bid does not mean that the whole bid should be set aside if this court, this tribunal finds there's an irregularity. So only which part is inflicted should be questioned, and then we go to the relevant discretionary part as to what would be just and equitable. Just to make it very clear, the two parts that
I think your submission there is similar to Mr. Mujapuli, to the extent that he proposes alternatives.
Those are the alternatives, but what do we do with the part of if there's a straight out order to repay? Is it for the whole of the bid, or is it limited to the construction part? And the court will, and the tribunal will follow my submissions. Why I, from the outset, make these submissions, because I think the only arguable irregularity, and I'm not conceding to irregularity, is the construction.
Yeah, I'm with you.
May it please the tribunal.
Yes.
Now, the irregularities are set out, and I'm going to deal with them as and in the same order as my learned friend did. Starting then with the amendment of the tender from the 12 months to the 3 years after the closing date. The critical question here, before I start making my submission, is what is the closing date? Where does that found effect on the facts that has been submitted to you? We must then consider the applicant's own evidence. Before the bid is advertised, already in February 2015, there's a memorandum that seeks approval, JN9, for Aero Medical Services for 3 years. So it starts out asking a bid for 3 years. Then JN16 in an undated specification document, which is referred to as the terms of reference, the TOR. The bid specification committee suggests 3 years. Now, then there are invitations sought in JN7 on the 6th of March 2015 the seeking of permission to place an advertisement, and only once the advertisement comes to light on 10 March 2015 does it specify 12 months. So before the advert, and we'll see after the advert, there's always been a 3-year period. Now there's an issue that the respondent, first respondent has, and that is when the advertisement was published in the Government Gazette, was there an attachment of the terms of reference? Because the advertisement...
Ms. Kilo, let me just understand, you are saying prior to the advertisement, there was a memorandum suggesting 3 years.
Yes.
But it wasn't advertised for 3 years.
Correct. I agree.
Okay. Yes, no, I understand. No, I just wanted to clarify that because I think I missed the memorandum somehow. Yes.
My pleasure, my lord. So,
all right.
The question is now, the terms of reference that refers to 3 years, when does it come to the knowledge of the bidders for the first time? Was it attached to the advert? We don't know. How was it advertised? Was it simply advertised with this one page we see in the record JN20 where it says on 10 March 2015 it's a bid for 12 months? Now, there's a conflict between the terms of reference that's been agreed on and what is advertised. But now we have an explanatory meeting, which takes place on the 23rd of March 2015, where a number of bidders are present. And we have the chair, Mrs. House, who gives an indication when we read the minutes that it is not going to be 3 years. Be very clear, it is only 12 months. What is the circumstances under which the 3 years comes to the attention of the bidders? Because we do not know, we do not have an affidavit. The approach by the applicant to use a forensic investigator to go and collect documents, attach them to his affidavit and make inferences leaves a lot of questions unanswered. The one difficulty for the first respondent is to try and understand at what stage did these terms of reference come to the attention of the bidders. Why do we ask that question? Because when the bid evaluation, the technical evaluation committee considers the only 2 bidders that come to the party to bid, that is Halo and Vusa. Both Halo and Vusa gives bids that make a submission about both 12 months and 3 years. How do they know about these about the time period of 3 years? The inference I can make on behalf of the first respondent, it's either advertised or it's disseminated at the explanatory meeting. Because when the bidders submit, they go and explain why 12 months is at what cost, because the question of cost effectiveness comes later. Now, the important thing that must be remembered, especially when we look at the other irregularities that my learned friend proposes, is
just there, but I'm not following. Are you saying there is uncertainty on whether it should have been 12 or 3 years? I mean, 12 months or 36 months?
No, I submit, my lord, at the stage when the bid is submitted, there are 2 sources of information. There's an advertisement that says 12 months, with the explanatory meeting echoing that, but there is terms of reference that were in place at that point in time, because you can't make a bid if you don't have terms of reference. And the terms of reference expressly says 3 years. So what does the bidder do? And
what happened? Do you know what happened at that meeting? That
is one of the questions I'm asking. How does the first respondent speculate if there is not an affidavit from Mrs. Gous, who's the chair? We have main points in a minute, but we don't have a detailed explanation when or whether the terms of reference was at that point in time first shown, or was it already included as an attachment to the advertisement. It's unclear. We don't know.
Let's accept that, yes, it's not clear, but subsequent communication, what does it suggest?
My lord,
But
what
because
happened?
subsequently, you then have the BEC, is it the DBEC, or but the evaluation committee that
Yes,
says 3 years.
yes.
We don't know
that,
where the source of that 3 years is,
well,
because from them, I beg your pardon?
it appears to be from the terms of reference, my lord. That's the closest we get, because when the
No, but what is before called? Oh, sorry. Is the or are the terms of reference before me?
yes, my lord, they are.
I haven't seen them. Are they an annexure?
There's an annexure, J in 17, where it seeks
Yes.
and it's dated the 6th of March 2015. So that's before the advert, 10th of March. It's before the meeting on the 23rd of March.
Yeah, but let me just complete what I was going to raise. The BEC says 3 years.
Correct.
In July, is it, or June?
Correct.
But subsequent to the meeting, it says 3 years. The BAC reverses that, says no. This was advertised for 12 months. I'm not sure whether they made reference to the terms of reference or not.
They don't.
And
They
ultimately, the two meet and say 3 years. They
Correct.
don't. I'm not sure whether they refer to the terms of reference or not. They seem to. I beg your pardon? They did.
They did not, my lord. The only time when it becomes relevant is when there's a comparison at the technical evaluation of the two bidders' bids, with both VUSA and Halo is still before it. At that stage, already there's a decision of cost effectiveness for 3 years as opposed to 12 months. So that's where the discussion starts.
Yes.
We should rather look at 12 months. So there's an up and down referring back, and then in the end of the day, come September, 30th September, when the bid is now going to be accepted, then at that stage, it is now agreed between the specific committees that it should be 3 years. There's an agreement.
Okay, carry on.
Now, the one point I think is of great importance, my lord, to take into account, because it will impact on the submissions that was made by my learned friend when he talks about bidders. When the evaluation is done on 29 May and they accept the 3 years, there were only two bidders in play. That is VUSA and that is Halo when the scoring starts. There are no other bidders that are in play, that are communicating, that are engaging with the Department of Health to give them quotes and bids. So when the complaint is that there's a change from 12 to 3 years without informing other bidders are not in the picture. It's only VUSA and Halo. VUSA knew exactly what the 3-year period entailed. So there's no prejudice for the remaining bidders. There's no evidence now as to why should any other party have been informed and at what stage about the 3 years. So my submission on behalf of the first respondent, because of lack of clarity, lack of evidence, and the absence of affidavits in particular, this ground is not reviewable. It does not constitute an irregularity. The 12 to the 3 years involved the relevant bidders. They had full knowledge. Then,
but yes, that might be so to the bidders, the other bidders. I think this is what I was raising. But I think Mr. Mjapulu's response was that, look, it's not only about the bidders, but perhaps it should have been reopened to the whole public again. Some parties may have thought it wasn't worth their while because it was for 12 months. For that reason, they did not submit anything, any bids to the committee. So it would be unfair for now, at this stage, to say no, we are changing.
To that, my lord, I submit that there were a number of bidders, 9 of them, who signed the register at the compulsory meeting. Only 4 took bid documents and only 2 submitted bids. That was at a stage where I'm asking the question on behalf of the first respondent, was the 3 years on the table or not? We don't know. So for my learned friend to ask for the tribunal to set this aside, whilst there is a mist of uncertainty as to when exactly was the 3 years disclosed and in what fashion, not after it received the bids and it was considering the 2 bids. It was
so that's your point, yes.
Before, not after. Therefore, on that basis, on the vagueness of the information, the uncertainty as to when it was established that it's 3 or 12 months, and that both possibilities existed already at the advertisement and definitely at the information stage, disabuses the submission that there should be a review of the time period changed. Thank you. Now we move to the second ground that the tribunal is asked to consider, and that is the letters of appointment of the Free State Department of Health for the 2 committees, the bid evaluation committee and the bid adjudication committee. My submission is that the evidence yet again is very scant that's placed before you. What is the basis on which the applicant wants this tribunal to make a finding of irregularity? On a very simple submission, it says, we asked for documents, we did not get letters of appointments for these 2 committees. Is that sufficient proof for an investigator to make an inference that they were not appointed? Again, I repeat my lament. What can this tribunal do in the absence of proper evidence, affidavits, and not just be satisfied with an inference drawn by an investigator who asks for documents and doesn't receive it? Here, we did not argue the condemnation part. There was severe prejudice, and I think it's from the heads, simply on the factual submission, the long time period that has elapsed and the unavailability of information. So what is put before this tribunal is the best that the SIU could do, but it did not go one step further and get the proper direct oral evidence of persons. Were you appointed? Were you not appointed? We did not have any explanation why this approach wasn't followed. So the evidence is weak and even less persuasive than on the first ground. For that reason, that irregularity does not exist and should not be reviewed. Now we get to the only irregularity that I submit has got a bit of meat to it, and that is the contravention of the Construction Development Board, Industry Development Board, and the contraventions of its regulations. What we again must bear in mind is that the bid and the evaluation happened on a simple individual document. There wasn't a separation. My learned friend correctly argued there should have been 2 bid adjudication committees, evaluation, technical specs, and everything should have been done as required by the legislation for the supply chain management. There's a number of transgressions here in not putting these 2 bids in 2 separate contracts and consider and adjudicate them differently. Because if there is now a finding that
wow, is she gone again?
Yes, she is. She's frozen again.
Okay. Mr. Mjapuli, in case that, do you have that their number, Mr. Shilan? Their number.
Thank you, Judge. I have
No.
the junior number. I'll call them now.
Oh, okay, but thanks, Mr. Mjapu. Children, you should have them on their heads. The number of Ms. Killian and I mean the attorneys in particular, or from the papers.
Oh, sorry, I think you're back.
Oh, you're back. They were back just now.
Not yet. They're
Oh.
not yet back. They're still trying to get on. It's on and off. But I'm
Oh,
with them
okay.
on the phone. I'm with them on the phone.
Oh, all right. I'm going to mute Mr. Mjapu. You'll just shout when you're ready.
Het was ek ook okay, die mense moet wees nou. Okay. Die mic is
It's not going well in Joburg today, ne? Yes, this is mute. You are muted.
Was that? Just when I suggested the contract must be cut in two, I went offline.
Yeah, it's not us. We are not sabotaging you. We are very firm.
Hey.
Okay, the judge just said he will shout when we are ready. I'm not sure whether Mr. Chilwani can hear us.
Yes, we can hear you. Thank you.
Oh, I think they are ready.
Thanks for coming back.
Uh,
Okay, Mr. Killian,
My
you may
apologies.
proceed.
My
That's
apologies.
fine. I'm sure it's beyond your control.
Definitely. Just as I suggested that the contract should be cut in two, I got cut off the line. So I will go back to where my suggestion is that is what is provided for in the legislation, that the extent of voidness is limited to that of the construction board requirements. So if the tribunal is inclined to declare the bid for the construction work void, there are a number of things to bear in mind when that is done. Firstly, that regulation 24 sub A of the Regulation 692 dated 9 June 2004 for this industry board, construction industry board, is applicable to state organs only. But 4 of the regulations deal with the invitation, awards, and management of construction works that is invited by an organ of state. And it explains the framework and the standard of construction and the guidelines in that regulation, and as well as the tender period, the tender procedure that should be followed. Now, having said that, the question is, if there is no legal obligation, and I did not hear my learned friend argue today, that the first respondent had a legal obligation to have the tender advertised on the website of the Construction Industry Development Board's website, then the assessment of what is just and equitable is impacted, because we must also at this early point in time bear in mind that there is no complaints from the applicant that the construction work, that's the helipad, very aptly described by my learned friend as a parking and a garage, which I will go along with, and the construction of the hangar was substandard, that was defective work. There was no complaints in that regard. It was only that it was impacted by the absence of compliance with this construction regulatory requirements. That is all. In other words, whatever the applicants paid for, they got. Now, I will come back to that submission because that should be taken into account once a decision is made. How do we deal with the construction part of this bid? Then I did not hear my learned friend persist, but in his heads of argument, he has the irregularity of the withdrawal from the national RT tender. My submission is that, again, is not an irregularity.
Let's just go back, Ms. Killian. What is your submission with regard to your previous point? You are saying there's no complaint that there are defects or not. So what?
When one has to look what is a just and equitable remedy.
Yeah, so it is still a transgression, but you say when you look at what is just and equitable remedy, you have to take that into account.
Which I will return to. I'm just making the submission that on the evidence available, it was the irregularity that if there's an application for voidness of that part of the bid is limited to a transgression of the regulations of the Construction Industry Development Board. That's the extent of the irregularity, nothing more than that. In other words, no malfeasance on behalf of the first respondent, no failure to deliver work. I will return. So I end my submissions on the construction board to go forward to the next irregularity that's in my learned friend's heads of argument. And although he did not persist or argue today, I will briefly just go analyze this irregularity or alleged irregularity. And that's the withdrawal from the national RT tender, that wasn't regular. The tribunal will remind itself when the history was put forward in the affidavit of the applicant that there was a national tender, and then in 2014 there was invitations and submissions why it should become provincial. And the complaint is that that withdrawal was not done by Mr. Maslachi, the accounting officer, but by the head of the Free State Department of Health, Dr. Matau. Now, that is the irregularity that is put before you. However, again, the complaint of the first respondent with this alleged irregularity is, where is the authority that this is a withdrawal that is limited to the accounting officer? We don't know which regulation, which directive, which legislation has been contravened. And in order to assess whether there's a contravention, there must be a standard that there's a deviation from. We don't know what it is. First, the second point that was made under this RT tender is the fact that the Free State Department of Health, at the stage that it suggested its own tender procedure for aeromedical services, it was under administration. Yet again, a simple say-so. There is no proof of what is the nature of what is considered as administration, when did it come into place, what were the powers, how did it impact on the head of the Free State Department of Health. In other words, what was he allowed to do or not to do? This, again, shrouded in mist. This irregularity does not rise above a mere say-so with no proof of how this tribunal can assess whether there is irregularity or not. So that, in my submission, does not take that irregularity any further. Now,
the heads of department, what do they do? Is that not prescribed in a particular legislation or provincial legislation, what their duties are?
We would like to know, and we would have liked to see such legislation attached and referred to. In particular, if there's an allegation up in the air about Dr. Matou's ability to sign or not to sign. We don't know. I then end the submissions on the withdrawal from the national tender to attend to the next irregularity that's listed. The complaint about the validity period of the bid expired when the contract period was extended. To a certain extent, this dovetails with the first submission. It's a bit of a intertwined submission. However, what I did not submit and bring to your attention, my lord, is the fact that the holding of the bid and extending the bid period was at a stage in July 2015, when the department sends a letter to the first respondent and say, hold your bid. Why? Because they are still busy putting the contract into place. Now, it's a bit of a misnomer then to say that the bid period was extended. The bid was done and dusted. It has expired. They are now busy putting terms for an agreement into place. And that is what HALO is asked to put on hold. So reading JN 44, asking HALO, hold your bid, which is a request after the expiry date. My submission is that that is indeed not an extension of a validity period without the knowledge of other parties. It is refers to something completely different than what the applicant wishes it to imply. So an extension is then agreed between HALO and the applicant, I repeat, the third respondent, on 31 August 2015 to 28 August 2015, and again to 30 September 2015 to finalize the terms of the agreement. It's clear.
So you say the bid had been by then had been finalized.
Correct. It's the contract that was now under exchange between the parties, the terms of the contract.
So the contract that would be entered following the award of the bid.
Exactly. After the bid has now, all the preliminary arrangements and procedures has been complied with, now they must sign a contract. And this contract, and that it is pertaining to the terms of this contract itself and not the bid period, is very clear when JN 51 to JN 54 is considered by the tribunal. It will become abundantly clear that there's no extension of the bid period. That's an incorrect interpretation of what happened. The bid was already accepted. Everything was, there is a signature that now should take place. Now, having said that, I submit that there was at this stage no question of a bid being open to the public. That time has come and gone. And the authority that my learned friend relies on is very good authority from the Supreme Court of Appeal, but it provides for a different set of facts. The guidance and instructions given by the Supreme Court of Appeal in that authority is when, if we look at the Takabusa case, for example, where there was a bid in Ekurhuleni for services, then the COVID pandemic hit everybody, and the bid came to a standstill for a period of time. And there were a number of bids, a huge number of bidders there. After a while, letters were sent out and said, let's extend this because of COVID. And I think it was extended for a second time. Now, Takabusa wasn't given the tender. And it complained. It said, I never got an email telling me that the bid period is extended. This is not where we are. When we get to fine-tuning the terms of the agreement, that's long gone. The bid period in Takabusa's case is not the same facts, not based on the same facts as what we have before you at this point in time, my lord. So I submit that there is no irregularity to review here. Not that it's got faint or inconsistent or vague evidence. It's simply not an irregularity. It should not be considered. That, my lord, will bring me to the last complaint of irregularity. And that's the unlawful extension of the second helicopter. In other words, we had a Bloemfontein helicopter flying, and then at some stage, the Bethlehem helicopter is added. Now, what is the offending legislation that enables a variation of an agreement? Because if you find, my lord, that legislation has been, or regulations have been contravened, then you are in the position to assess whether it's irregular or not. So the National Treasury regulations and provisions regulate the question of variances or variations to a contract. It's paragraph 83 of my learned friend's founding affidavit. The condition is, if you do a variation, it must not be more than 20% or 10 million of the original contract. That you can do it.
Is it 10 or, sorry, is it 10 or 20?
20.
It's 20 million.
20 million, my lord. No,
No, you said 10.
I apologize, and I'm sure the court will be hearing me much better than I'm hearing myself at this point in time. Thank you for the correction. The answering affidavit engages with the founding affidavit in paragraph 27, and it says, you are making the wrong calculation when you say it is more than the allowed variation percentage. Firstly, you put both contracts, that's now for one helicopter and the second helicopter together, and then you make a calculation. You can't do that. That's the cart before the horse. You first have to assess what is the value of the contract that is in place that must now be varied so that it amends and includes a second service. Cannot add the value of both of them. There's no example or authority anywhere that this is the procedure of making an assessment. So we strongly challenged this calculation, and we say in paragraph 27.2 that the base total should be the 54 odd million rand and not the 91 million that the applicant suggests. And once that is done, it is clear that we fall within the percentage. So again, this is not irregular.
I thought the value of the second contract, what they got from the second contract, the Bethlehem helicopter, was about 35 million.
Yes, my lord.
So what is the 91 or 94 about million?
So the 54 that the first respondent submits is the value of the Bloemfontein contract. If you take the Bloemfontein contract and you add the Bethlehem contract, then you will get to the 91 million rand.
Oh, I see what you're saying. So you say the 20% or 20 million is considered on, or is calculated based on the 91.
Yes, which is an incorrect calculation. You can't add the
Yes,
one that.
No, I get you. So, but let's just look at the 35 million. If it's 20% or 20 million, I guess it's whichever is greater. Am I right? Or it has to be that way because it can't be both. So you can't exceed 20 million or 20%.
Correct.
So
Correct.
35 million exceeds 20 million rand. I mean, sorry. Yes. 35 million is more than 20 million.
Yes. So when we make our submissions and our calculations in our answering affidavit, paragraph 27, we set out step by step how we arrive at that. Why are we saying it's not a contravention?
Enlighten me. Why is that wrong? That's exactly 20% may be probably, but if it's 20% or 20 million rand, I'm saying 35 exceeds 20 million rand, and just help me there get over that.
I'm going to just get the specific submissions in the affidavit, and I will read them to you, my lord.
All right, thanks.
So I am on page 9 of section 9, which is the section for the answering affidavit, and I'm referring to paragraph 27, where the contents of the calculation made in the founding affidavit is denied. The submission in the first subparagraph is the monetary value of the extension as stated by the applicant is correct. However, the applicant errs in its calculation. 2, the base total of 54,317 million was only for one base and not two, Bloemfontein and Bethlehem. The correct amount for both is 91,154, 91 million. This represents a variation of 11.72% and not 19.67% incorrectly stated by the applicant. Therefore, the variation is below the prescribed threshold. That is how we have dealt with it.
Yeah, but well, look, but that confuses me, and I think it will take more than you've just done to bring me into the loop to understand it. Now, I'm not sure why you. Well, okay, I look at the 35 million only, so I isolate the Bloemfontein from the Bethlehem, and say, yes, has the threshold been exceeded? And the threshold to me is the 20% or the 20 million percent, but the 20 million rand. And I'm saying the 35 million is higher than the 20 million, regardless of what 20% of 35 million is.
Yes. Well, it is on one of the two. It's either or. It can be for 20% or 20 million. That's not equal.
Yeah,
to
so it's 20 million of what? Of 35 million?
Of the original contract. But it's a percentage that must be calculated. And the percentage is calculated with the correct base number. It is less than the 20%.
Okay, let me understand this. What is the 35 million?
That is the second contract's value.
Yes, I'm talking about the second contract, because we're talking about the second contract, aren't we?
Yes, my lord.
Yes. So let's forget about Bloemfontein. So the respondent made about 35 million. I don't know what made means. Is that profit or gross amount that they received?
Invoiced.
Invoiced. So that would be gross, ultimately.
My lord, might I just have a minute? I see somebody's done a calculation here. I might be telling the court the incorrect information, so I apologize. Give me 1 second that I can take note of the note that has been passed.
Right.
Calculated. Only Bloemfontein.
Okay, we can hear you. If you want to mute, you can mute.
Thank you. Thank you for the indulgence. I have been corrected here, and maybe that's why I confused the tribunal, for which I apologize. The correct approach should be that the value of 58 million of the existing Bloemfontein contract should be added to the 35, which gives us the 91. I changed it around. It should be the 91. And then the calculation of the variation comes to 11%.
Okay. I'll try again later. That's fine. Carry on, Ms. Kenyon.
Thank you, my lord. I must say this is also not my strong point.
Yeah.
So, if it is so that the calculation is incorrect, then the whole thing is based on the submission of the Treasury regulations. Then I submit that irregularity does not hold water. That is the gist of my argument.
Yes, I understand.
Now, I want to do a bit of an interruption of my argument before I go to asking what is the relevant remedy that we're looking at, which takes us to the second part of section 172. What is in the papers and what I did not hear submissions on today was the question of the first respondent overcharging and getting paid for work that he did not done on the aeromedical part of the contract. Now, though it is not one of the irregularities that the tribunal is asked to consider, it is an important fact, because if I'm going to make a submission in a few minutes that the first respondent's hands are clean, then we can't have this suggestion that it overcharged and made money out of a contract that it was not entitled to do. And those submissions that are in the papers and that were to a certain extent in the first set of arguments was that the supplementary affidavit is filed in order to show you an 100% accurate calculation of invoiced and paid amounts. Invoiced, yet again made up of flight hours, folios, and a number of information that was not taken into account by the applicant when it put its tables in the founding affidavit. We consider each of those different tables and show why there is no overcharge. To summarize what it entails, if there's consideration to the supplementary affidavit, the reasoning lies with when the applicant, when is the first respondent entitled to start charging for 19,950 Rand per hour as opposed to the 14,000 Rand per hour. That's where the nub of the debate lies. The original agreement was that there would be a 3-month period, which they call the setup phase, where there will only be 12 hours that will be flown. Because remember, there are not helipads everywhere. We don't have power everywhere. There are certain things that must be put into place. Certain constructions must be done. So only 24 hours service is given at a certain rate. Come the 4th month, up until the end of the agreement, there is a 24-hour service that's delivered. It's a package deal. You are going to fly 30 hours in a month at least, and you're going to give us 24 hours service every day. But once you fly more than 30 hours, you are now entitled to the increased rate. Forget about the 14,000 Rand per hour. That fell within the first 3 months. So what does the applicant do when it calculates and says you're overcharged, you've got money that you're not entitled to? It continues to calculate on 14,000 Rand for the extended hours, going beyond the 30,000. Why does it do that? It says that the construction wasn't complete. You're only entitled when the construction is complete to ask the increased hours. So I'm going to look at your billing and I'm going to cut it down and say that you're overcharged. That is what they do, which is in conflict with what was agreed. Secondly, they do an average, saying there was some downtime. We take a certain amount of months, not every month, we work out what an average is, and that is how we will come to the conclusion that there are overcharging. Now, that is also incorrect, because if we look at the supplementary affidavit, we look at the electronic information supplied, there is accountability for each and every hour, for each helicopter that was used, and there cannot be an argument that there was charging for hours that were not flown. That is why it was necessary to go into that detailed calculation to demystify this allegation of overcharging. I submit that there's sufficient evidence, factual, actual, documentary evidence, to not indulge in the applicant submissions that there was overcharging. It cannot be countenanced. My submission is, once that is taken into account, one can now start asking, how do we remedy whatever parts are found to be void? Now, over a period of time, there has been conflicting decisions, unfortunately. When one starts to ask, how do we fix an agreement that is now declared void? And then the particular question that I want to draw to your attention, my Lord, is what do we do with the innocent third party, the innocent service provider? My submissions are made bearing in mind that one should separate the two contracts, and I'm going to make my submissions now firstly pertaining to the aeromedical contract, and then I will look at what is to be done with the contraventions that is proved in terms of the Construction Industry Development Board, because that, in my submission, is the only real issue that should be reviewed by this tribunal. So what we have is the cases relied on by the first respondent is, I'm going to just refer to the names of the cases. They are all in our list of authorities, as well as somewhere in the heads of argument. Bengwan Yama Minerals and others versus Ganora Resources, a decision of the Constitutional Court in 2010. And I think it is important that this tribunal has regard to paragraphs 84 and 85 of this decision. I quote with your permission. Context of third parties having altered their position on the basis that the administrative action was valid and would suffer prejudice if the administrative action is set aside. The desirability of certainty needs to be justified against the fundamental principle of legality. So have these two pulling forces. You have a party that engaged on the basis, like the first respondent, with the Department of Health, that they were entitled to put out this bid and the administrative action was in order, and we change our position to incur costs and we fulfill the requirements of this bid. So the declaring 85 of the same judgment, the declaring of conduct in conflict with the Constitution is for the providing for a just and equitable remedy. And then this case enjoins any reviewing authority. Look at each case, determine the facts individually. Then look at the interest involved, and not least, what's the materiality of the breach. That is what Bengwan Minerals say in short. Then we have the very well quoted case of All Pay, which I think is an important case because it gets quoted and misquoted, and even misquoted in certain subsequent cases that follow after it. All Pay and others, there's a 1 and a 2. The All Pay 1 in the Constitutional Court deals with the inquiry into whether there was an irregularity that should be reviewed, and All Pay 2 then had the hearing on what is a just and equitable remedy. So it was divided into 2 different hearings. And the decision of All Pay is very instructive because it very clearly explains how do you go about a scenario which is on all fours with the fact that you have a party that innocently enters into an agreement and then subsequently after the service is delivered finds out there was certain non-compliance. So it emphasizes in all pay that once a ground of review has been established, then there is no room from shying away from it. And this is why I painfully went through each of the grounds that my learned friend put up as whether there is indeed a ground of review. I have to a certain extent conceded that objectively there's a deviation from the Construction Industry Development Board's requirements on the side of the Department of Health. Otherwise, there are no concessions or admissions of irregularities. Now, what if that part is found?
Okay, just there. Okay, I guess you're talking about, well, when you say on the part of the Department of Health.
Yes.
Would that be the two separate processes followed in respect of the procurement of goods and services, and the other one construction of infrastructure?
Correct, as well as not advertising on the tender board of the tender website of the Construction Industry Board.
Yeah, now, I just want to come to that. Whose responsibility was that, the advertisement?
That is where I made a submission.
Is it the constructor or the department?
The
that
department
should have registered?
The department is enjoined in terms of Regulation 25. Must I give the court, the tribunal, the whole reference of the regulation?
Please. You say, please. The regulation is quite necessary. It's important.
May please, you, my lord. So the regulations is number 692 in Government Gazette 26427, dated 9 June 2004. The regulations in terms of the Construction Industry Development Board. And then I will take the tribunal to part 4, which has got a heading, Invitation, Award and Management of Construction Works Contracts. Regulation 23, this part applies only to a client or an employer who is an organ of state. So it's got a separate part that enjoins the department, which is an organ of state, to do certain things. And what they should do is in Regulation 24, how to prepare for the construction procurement. 25, how to invite a tender. So it is very clearly, and there can be no doubt that the obligation was on the applicant to do what he did not do. So, in other words, what I'm trying to bring over is that the first respondent is an innocent third party to what has happened, where exactly the matter that I just quoted makes provision for. If you are part and you connive and you agree and you collude with the department and show, look, if you give me this contract, this is how it's going to work. There's no evidence of wrongdoing, malfeasance, corruption, nothing. It is simply non-compliance with certain provisions that lied within the ambit of the duties of the Department of Health when it entered into this agreement. So then coming back to where I was referring to the all pay case, where they correctly asked me, what is the consequences now if you are a third party that are innocently drawn into this situation? The validity must then be determined. No, it's not valid. Now, what is fair and equitable? And all pay gives us a good indication. I think my learned friend also touched on this case in paragraph 58, that the materiality of the irregularities is determined primarily by assessing whether the purpose of the contract requirements were substantially achieved. There was a very old approach of what is mandatory and what is directory. This is now the new approach in 2013 by the Constitutional Court. Has the purpose of the agreement materially been achieved? Of course it was. And I'm again referring and emphasizing the construction part. The helipads are there, the hangars are there, there's no fault. The value was given. And in the same breath, the annexes to the supplementary affidavit shows the amount of hours flown and the work done. It is no debate by taking an incorrect calculation and then asking this tribunal to punish the first respondent. That's not correct. Should not be done that way. So apart from this cursory debate that's not classified as an irregularity of incorrect calculations, no other complaint is found in the papers of the applicant, and I don't hear my learned friend making submissions in that regard. So these are the facts on which this tribunal must make a decision.
So just tell me, in the event of the hangar or the helipad being incorrectly constructed and permitted to be used, in the event that there is, it turns out there is a problem, and say an accident occurs, is it just a simple matter of suing for damages?
I would assume that would be the correct approach.
Because I would have assumed that the authority
yes.
should take responsibility, and that's why you need its intervention in the sense of approving.
Yes.
Now, if so this just leaves the person who constructed the infrastructure to this thing to be sued for damages and nothing else.
Correct.
All right. Yes.
Correct. And there is provision for that as well. And we don't have that quantification or allegation. But now, what is... Mate, please. Please, you might. What must happen when we are in a scenario where we find an innocent third-party service provider, as I submit is the position here? There's a very new case that really looks at all the authority, and it is in my heads of argument on behalf of the first respondent, my lord, and it is the decision of Pumelo. Pumelo is a decision of the Supreme Court of Appeal that considers all pay, that considers the incorrect decisions made previously by other courts by incorrectly quoting all pay and saying a person is not entitled to benefit from a contract that's void without going into the second inquiry. There was a full bench decision that was criticized. I deal with it in my heads of argument, but I'd rather consider the principles than criticizing other cases. The contextual consideration of all pay shows today, this is what Pumelo says, that the Constitutional Court did not hold that a party could derive no benefit from an unlawful contract. The approach in All Pay 2, and the tribunal will recall that All Pay 1 is the assessment of the irregularities, and All Pay 2, the subsequent decision was the making of a finding of what's just and equitable. So in the second phase of the inquiry, the Constitutional Court said there's no authority to say because the contract has been unlawfully entered into that nobody can have a benefit from it. That's not the law. The law allows a party to retain payments and benefit under an unlawful contract, but it wants to put an obligation on such a party to make it clear to the public in general to be responsible and account. Now, let us look at the alternative relief of what the applicant is asking. The applicant is asking a blueprint of what is contained in All Pay 2. It says it must account, and then there must be a response, and then if necessary, we must come back to this tribunal to assess whether those expenses are fair. What it cannot say, or what All Pay does not say, is once you have calculated your profit, you must pay back the profit. That is where the misunderstanding and interpretation of cases up until Pumelo has led astray, that there were findings of pay back your profits. Not when you're an innocent party, not when there's a benefit for the department, and not where it can be said that you did not do your duties properly, you were not complicit in any of these irregularities. So the alternative relief sought by my learned friend is on par. Go and do your calculation so that everybody can see how much you benefited. That's the end. Or I don't have to make any order against you because of the degree of you not being complicit, and it is clear that the oversight falls totally within the ambit of the applicant, the third respondent, the Department of Health. So those are the only considerations that I submit. I make it more clear in my heads of argument. I detail more how I get to this argument with quotes. But my submission is clear that there is only one just and equitable relief. And that is, after assessing, this court now goes into the realm of discretion, not into an obligation to make an order. The applicant in the main says, pay back this amount of money. It doesn't really quantify it today, somewhere in the papers, how much should be repaid. That amount, unfortunately, is where the allegation of overcharging finds its way. And it is included in making an inflated calculation of paying back all monies that you were entitled to, not even what you were paid, because if I can maybe remind the court of the Trompsburg helipad and the fact that the applicant includes payment for Trompsburg, while in the meantime, the first respondent is suing Trompsburg for payment, puts it into the pot and asks this tribunal to make a finding that that money be paid back as well. That is untenable. There is no basis for such a finding. The amount is not properly calculated. The only consideration that the tribunal must make at this point in time on the law as it stands today is, shall this tribunal direct the first respondent to account publicly? And that's the end of the matter. My submissions is that is as high as this case can go. Having said that, we then get to the debate on costs. And I want to remind the tribunal about something. And that is that during the investigations, only the Department of Health was engaged. The first respondent wasn't approached, and the SIU applicant has got all these powers in the Act and in the regulations. It can bring any party to its office, direct it to bring documents, inquire from it what's going on here, and ask it to explain by way of affidavit. That wasn't done. There was no invite. In fact, the applicant is quite strange on this position. He says, I don't have to ask you. I asked the department and I got what I wanted. There's no obligation to engage in it. No, there is no obligation. But if a proclamation tells the SIU to investigate malfeasance in the Department of the Free State, it's got the power to ask all third parties and service providers, what do you know? Come here, hello, sit here, bring your papers, let me see what you've done. No, it declines and it persists with its stance that it's not going to engage. We'll see you at the tribunal. Here we are at the tribunal. And there are many things that could have been exchanged, clarified, maybe not even bringing us here. And in that regard is where I submit that the category of costs fall within punitive costs because it wasn't necessary. That is if this tribunal finds that it's not going to take action. Obviously, if it's going to take action, we must look at partially successful and so forth. It will be on a scale depending on your judgment, my lord. And those are my submissions.
Sorry. All right, I see it has just gone 1 o'clock.
May I be permitted to just come back with a better calculation? I believe of the people ready here to give me that calculation just before the applicant proceeds with its reply.
That's fine. Don't close then. You'll just carry on for a few minutes after 2.
Thank you.
Will that be fine?
I need to consult to get the calculation during this break, if I'm permitted to do so.
Yes, no, that's fine.
Thank you.
Are you talking in respect of the 35 million and 91 million, whatever?
Yes.
The Bethlehem part.
I hope I can be educated in that way during the lunchtime.
So you can educate me, perhaps.
I hope so. I hope so. Thank you, my lord.
Thank you. then the tribunal adjourns until 2 o'clock.
As it pleases.
Thank you.
case number GP07 of 2023, SIU versus helicopter and airplane logistical operations, and 2 others.
Yeah, good afternoon. Are we all back on?
For the first respondent back, my lord.
Yeah.
For the applicants, we are back, my lord.
Good. Ms. Killen, please proceed. You wanted to take me through the calculations.
Correct, my lord. And I will start with the founding affidavit, where under the heading of payments made to Halo after the contract term came to an end and the extension of the contract deals with these calculations. So the first step is to direct the tribunal to paragraph 204 of the founding affidavit, where the authority to extend or vary or amend an account lies, and it is within the National Treasury Supply Chain Management Instruction Note, where it reads, and I think it's important that I read the whole paragraph, the accounting officer / accounting authority must ensure that contracts are not varied for more than 20% or 20 million brackets, including VAT, close brackets, for construction-related goods, works, and or services, and 15% or 15 million for all other goods. So the 20 million or 20% that's permitted is for services from within which the aeromedical services would fall. So that's the starting point to do the calculation. That's the source. Then still with the founding affidavit of the applicant, I now direct the tribunal to paragraph 210. And I'll read again because this is I think the important part of the argument that I missed before lunchtime. The recalculated amount in respect of contract extensions to equate to 10,683. So it's just over 10 million rand. Now here is where we divulge, because the applicant says this represents 19.6% when you divide the 10 million into the 54 million value of the contract, which, by the way, is still under the 20%. And I'll make that just remark now, but I'll conclude with it in a few minutes. Now, going to the answering affidavit, paragraph 27, and that was the only part I referred the tribunal to before lunch, where there's a debate and a discussion about what is the base amount. Is it the 54 million or is it the 91 million? In other words, the combined price of the two contracts as the base amount. Irrespective of whether that is so, the calculation on the 96 million will take us to 11% variation and not 19.6. However, I submit this as a total red herring that I got thrown into very effectively, because whichever way we look at it, on the applicant or on the respondent's version, it is still less than the 20% that is provided for in the supply chain management policy. And that is my submission, that there is, in other words, nothing here to review. There's no irregularity.
Okay, thank you.
My please.
Thank you. I suppose that's it for your submissions.
Concludes my submissions, and thank you for the opportunity to add.
Thank you. Mr. Mjapil, in reply.
Yes. Good afternoon.
Yes, afternoon, Mr. Mjapil.
The first point I need to deal with is on the issue of the 12 months versus the 36 months. There was a submission, and I'm not trying to quote directly, but my understanding of the submission was that because the terms of reference referred to 3 years, then whoever got hold of the terms of reference would know that there was a 3 years period. And the sequence of event will have happened as follows. There is no advert called terms of reference. The advert, there is an advert and which said 12 months, which is published to every member of the public in South Africa. It says 12 months. The only place where one finds the so-called 3 years is inside the terms of reference, which were not advertised out to the public. And when one look at that annexure, annexure JN17.
But just there, Mr. Mshapil, do you normally advertise terms of reference?
No, that
So
is what yes, that is what I'm trying to say.
When do they become important?
Usually it's when documents are bought. For an example, in this matter, it is recorded that at the compulsory meeting, that is where the documents were bought.
So is that where one would get the terms of reference?
Yes, in our submission.
So, just the sequence, it will be, so firstly, it's advertisement of the tender.
Yes.
And then you are told to attend a compulsory meeting, briefing meeting.
Yes.
And that's where you find the terms of reference.
Yes.
At that stage, you would be knowing that the tender was advertised for 12 months, or they would have known that it was for 12 months.
Yes.
So why would you have a document with conflicting terms, or a document that contradicts what was advertised at that meeting?
That is why this meeting is so necessary and it's compulsory. That is where clarifications are, and I want to take my lot to that, to the minutes of that meeting.
Yes.
The advert itself, my lot, would have said it has 12 months, and then it says compulsory meeting will be held on the, I'm just paraphrasing, on the 23rd of March. It gives time and it gives the venue. Then at that meeting, that is where the terms of reference are already printed. So those terms of reference I was referring a lot in paragraph 6.1, which is a handwritten page 52. Handwritten page 52 of that document, but of the court papers is 001-230. That paragraph says the contract is arranged for a period of 3 years. This is now going to be found in the facts of this case by 9 bidders who attended the compulsory, potential bidders who attended the compulsory meeting. But that is why this meeting, you can never qualify if you don't attend. It's compulsory because that's where clarifications are discussed. And the minute is there. It is 2 pages, but the first 2 bullets will support what I'm trying to say. It says, this is the minute now. It says matters discussed. Mrs. House handled the bid document and highlighted the following. This is what was told to the bidders. The attendance register was circulated to all bidders. And then bullet point 2, the following corrections were made to the bid document. The first one was SBD 32 form. That SBD form will also have not been in the public, but it will be found by the people who will buy the document. SBD 3.2 form, the bid number is so and so, and that bid number is not correct. That's what the information says. And the most important part is the one that we're dealing with. The bid for a period of 1 year, in brackets 12 months, and not 3 years. And in brackets, it says page 52. So that page 52 that I've just referred my lot to, handwritten page 52 of the terms of reference, was corrected to these 9 bidders who were there and who would have bought and seen it. So there is absolutely no confusion about the 3 years versus 12 months. 12 months is out there in the public for South Africans. And then those who think 12 months will suit them were 9. They came. And then when they were there, before or during the process of buying the documents, which documents will confuse them by 3 years, Ms. Holmes corrected it and recorded it here. So there is absolutely no confusion. That is why the BAC differed with the BEC and said, explain to us, why would you change this date after the closing date? So I did not understand my learned colleague's argument. And then she continues to say, and I apologize if I'm misquoting him, it makes no sense because it doesn't matter, because those who are there would know that there is this 3 years and whatever. But that is not what the case law says. And we've referred the court to Twabe. The case of Twabe, and we've referred to paragraph 42, but I think what is relevant is to study it from paragraph 41. One should further bear in mind that the plaintiff's defense, as pleaded in its plea, is premised on the fact that the decision was made known to all the tenderers. In the result, the plaintiff submits that the changed bid conditions were transparent, fair, all tenders were treated equally, and the bidding process was competitive. And the court says in paragraph 42, the plaintiff's submissions fail to take into account that the public, and more especially potential bidders, were unaware of the amended bid condition. In order for the bid process to be transparent, fair, equitable, the amended condition should have been published to give all interested parties an opportunity to submit competitive bids. What I'm saying is that the argument that those who attended there have seen this 3 year, the 9, does not help the respondent, because the advert which is out in the public is the one that says 12 months.
So what you say is not only about the tenderers, but about the public.
Yes.
Yeah, so who might have resolved whether to participate or not to participate.
Yeah. They decided not to drive to Gauteng for a contract of 12 months. They decided not to come. It's a true statement. Yes. So those are my submissions on the first point.
On that one, yeah.
Yes. So Twabe, although in our heads we refer to paragraph 42, to make the point, it starts at paragraph 41. The second point is the issue of no letters, and we are criticized because the letters could not be produced by the department, the appointment letters. Then we cannot rely on the failure by the department to produce. I mean, that's the best evidence we have. As investigators, we asked for the appointment letters, we could not find them. All we can submit is that the law requires appointments of those bidding committees to be in writing. If we don't have it, that's the best evidence we can have. And we said it in the founding affidavit, which was served to all the respondents, and there is no other conclusions that we can make. And we submit that the tribunal should make that inference and that conclusion that this is the evidence that we have. Now, the third point is the CIBD. I did.
But just there, I think the criticism there is that what stopped the tribunal, or sort of not tribunal, the SIU, to get those people to attend upon their offices to inquire what actually transpired and perhaps attach an affidavit.
Yeah,
as opposed to saying the letters were not supplied. No reason. So the tribunal must assume that they were not available, or that they were not available because these people were irregularly appointed.
Yes, what we want the tribunal to conclude is that because we requested the letters and we were not furnished with them, then the conclusion is that those letters do not exist. That is what the case that
yes, no, I understand, but couldn't you have gone further?
what
I'm saying the SIU, couldn't the SIU have gone further?
The request for documents, it's as good as a subpoena from the SIU.
So where do I find what is the authority for that?
Oh, the authority that the requests are made in terms of the act.
No, yeah, I understand. When you say it's as good as a subpoena.
Yes, yes, I do not have authority on that. But what, if I may go to one of the letters, it is a. I'm not going to say whether it's a criminal offense, but it's punishable if you don't respond. So to answer to my.
So what you're saying, I'm allowed, the tribunal is allowed to draw an adverse inference if there's no reply to its letters.
Tribunal to draw an inference.
So you don't say so.
Yes, that's the best evidence we have on this issue.
Yeah.
Yes.
Okay.
And we cannot take
it.
Yes. My lord, the third issue was the CIBD issue about the advert on their website. And in this regard, we have referred in our heads of argument in paragraph 66 to regulation 24. And I may be wrong, but I understood my colleague to be saying that it is not compulsory or it is not punishable, however she has put it. All I just want to highlight is that in terms of regulation 24, which we summarized in paragraph 66 of our heads, that is the second sentence. Regulation 24C of the CID regulations further provide that soliciting competitive tenders in the construction industry must be published or advertised on the board's website. And that is what the regulation says because I've just checked it. So I hope I'm not misquoting it, but I want to highlight that the law says it must be published on the CIBD website. That is why we say failure to do that is against the law.
But who must advertise it?
The department.
And the department failed.
Yes, the department failed. To answer my lord's question, who must advertise it? Maybe let me just read the regulation 24. Let me go to it now. It says,
but I think you agree with her, because she says the department is enjoined.
Yes, our submission.
And if that is the case, her argument is that she shouldn't be punished for the shortcomings of the third respondent.
Yes, she. I mean, headline is not being punished, but it is the consequential event of an unlawful tender. All we are submitting is. I beg your pardon, my lord.
No, there's nothing.
All we are submitting is that the unlawfulness, the failure to comply with the CIBD Act, one of them is the failure to publish on the website, and it is the department that must publish. If that is
so all you're saying is that transgression, it's sufficient to constitute a to be something unlawful, whether it's by the department or the first respondent, it's neither here nor there.
Yes, it is what we are submitting.
It's a sufficient ground.
It's a sufficient ground. It's failure to comply with the law by the department. It's the department that must publish the tender.
I'm with you.
Yes, yeah. So it is compulsory. It is failure to do that is unlawful. Then there is this
By
issue.
the way, how is that regulation couched? Is it in peremptory terms or merely? How does it read?
Yes, it is peremptory. It says must. Let me just, yes. It says every client or employer, this will be the department, who is inviting calls for expression of interest or soliciting competitive tenders without first calling for expression of interest in the construction industry must publish that invitation to tender on the board's website. And that solicitation must be in accordance with, and then it gives others. So it uses the
yes, okay.
Thank you. My Lord, then let me go to the issue of the validity period. And my learned colleague might have got it wrong here, because I need to go to the extensions. Yes, the first extension, it's what an extension. The first extension states that it's what is the name of the next? I beg your pardon. J51, JN51. But I have the page. The page is 001-418. That is the first extension. It tells us, is addressed to Halo by the department. So it tells us that the expiry date is 16 July 2015. Let me just pause here. My Lord will remember that the award was in 23 September. So it says the expiry date is 16 July 2015. And then it is also, it's dated 10 July. So it's dated before the expiry. It's 10 July. Then it says, a possibility exists that the above mentioned bid may not be finalized before the expiry of the current validity period. That validity period, I said, it's 16 July. The department would like to know whether you are willing to hold your bid valid in all respect for the further period indicated. And I'm not going to read everything, but the extended date requested until which the bid will be valid is 31 August 2015. That is the first extension. So for a submission,
Okay.
that at this stage, there was...
Just there, Mr. Mjapin, she said, and just so that you address it, she said at that point, the bid had been awarded and it couldn't have been the extension of the bid, but they were quibbling about the terms of the contract. Is that correct?
No, that is not correct. As I've stated now, the award was on 23 September 2015. So this is the purpose of before the award was made.
Yes, no, I'm with you. I'm just reminding you that that's what she said, and I want you to just make sure. I just want to make sure that you address it. So yeah. It wasn't the it was the extension of the bid, not negotiations on the contract of a bid that has been awarded already.
Yes, it was the extension of the validity of the bid to 31st. So it was not yet awarded. It should have been awarded before the 16th, according to this letter, before the 16th of July. And
the document from which you're reading, what document is that? That says it will now go to the 31st of August.
Yes. My colleague says it's JN 53.
Yeah. Well, what is the heading of the document? Do you have any?
Yes, the heading of the document is, it says subject. Subject of the document is extension of bid validity.
Oh, so even the heading says so.
Yes.
Yes.
So this is the first extension. It extended it to the 31st of August. And we know that by the 31st of August, they have not appointed. So they sent another one. Yes, the first one was in July. Now I'm dealing with the August one. Yes, the second one was in July, was in August. Same heading, subject, extension of bid validity. And the page is 001-422. I can't tell which lecture is this one, but it's page 422. So it's the same heading, extension of bid validity. And it says expiry date 31 August 2015. My Lord will remember this was the first request to 31 August. And then it reads the same. A possibility exists that the above mentioned bid may not be finalized. And then the last sentence is extended date requested until the bid will be valid is 30 September 2015. So we know that before the 30th of September 2015, the award was made. So the award was made on the 23rd of September 2015.
Hold on. Is that true though? Were they not awarded earlier than that, as early as March or April?
No, my Lord will remember.
So there's never been any award.
No. My Lord will remember that there was an April. Let me just go to the history. My Lord will remember that the compulsory meeting was in March. We are talking about 25th, and I'll just jump. And then the TEC, the technical committee, was in April, and the BEC was in May. The BEC recommended 3 years, and the BAC was in June 2015. The first BAC rejected this and inquired about these 3 years. And the second BAC set on 6 July, BAC 2, and is the one that recommended 12 months. And remember, the BAC recommends and it goes to the accounting officer. In July, the accounting officer refers the matter back, and I've read that there was a meeting on the 23rd of September where the accounting officer ordered the two committees to meet. They met on the 23rd of September 2015. Then they all agreed that it's for 3 years, and the letter of award was issued on the same day by the accounting officer. So there was no award before this date. There was still a debate.
Okay. Yeah.
Yes.
Thanks.
Okay. Yes, I'm lost now.
I'm sorry.
That was the validity period, and then yes, the extension of the second helicopter. I think there are two components to this argument of the extension, and it ties down with transparency. The first one is that nobody knew that there was going to be a second helicopter. That's just untransparent as it is. It's unlawful. But then the second component is the one that my colleague is dealing with, which is the threshold. That even if you extend, you cannot exceed a certain limit.
That's where the calculation coming. Okay, so what you're saying, the first thing, okay, so there can't be an extension unless one or two things happen. One of them, I think, at play now is the 20% or 20 million rand. It must not exceed that. And that doesn't mean that it can't be done, but I think there are provisos. It must be done under certain conditions, but that is just one of them, the 20%. Or how you calculate that, I'm not sure. Do you combine Bloemfontein and Bethlehem and then get the 20%? But she referred to variation. What is that? How do you get to that variation? How do you get to that the variation of 11 million?
Yeah. Just hold on. Okay. Yes. Before I even answer that question, my colleague helps me here that the reading of this instruction, it says the accounting officer must ensure that contracts are not varied for more than 20% or 20 million for construction-related goods, works, and services. But the important one is the second one. And 15% or 15 million for all other goods and services of the original contract. So in as much as we are grappling with
also of the original contract.
Yes. Of the original contract value.
So the original contract would have been Bloemfontein, am I right?
Yes.
Because there's the one that was extended. And what was the value? Is it the value of that contract or what? How do you calculate the 20 million or 15 million or 15%? When do you say they've exceeded it?
So in paragraph,
anyway, so it's clearer now. So it will be 15% or 15 million of the original contract. So which means must be based on the contract in Bloemfontein. That's the original contract.
Yes. And my
so the question is what was the value of that contract?
In paragraph 208, I beg your pardon, paragraph 208 of the founding affidavit. Let me just read it out loud. The assessment made by SIU indicates that the expansion of the contract after the expiry of the initial term exceeded the original contract price by 10.683.401. And then the calculations in brackets is 1.7 million odd amounts times 3 months times 2 helicopters in respect of the contract extension for 3 months period from 1 October to 31 December 2010.
What does it come to?
It comes to, yeah, the numbers are hitting me. It comes to, because we say the recalculated amount in respect of the contract extension equates to 10 million, and then that is paragraph 210. This represents 19.67 of the contract.
But then you agree with her, it's still less than 20. It's less than 20 million.
Yes, my lord, the calculation here is 19.67, which is less than
20 million.
20 million. But can I go back to that definition, because 20 million is for construction? Can I read it again?
In respect of all, it's 15%. Okay, yes, read it again.
Yes, let me just read it again. And the paraphrasing is on paragraph 206. 204. The accounting officer, that is paragraph 9.1 of the National Treasury, the accounting officer or accounting authority must ensure that the contracts are not varied by more than 20% or 20 million for construction-related goods, works, and or services. Then there is a big end, that is me paraphrasing. 15% or 15 million, including VAT for all other goods and or services of the original contract value. So if it is a pure contract, construction, it is 20%. If it's for all other goods, it's 15% and 15 million.
So which one is affected here? We're talking about construction. No, not construction, and we're talking about both, actually.
Yes, in fact, here we are talking about both. But they kept on saying that, I mean, although they are not correct, but the department, and they kept on saying that this was a pure health contract, and the construction was by the way. But in our argument, is not.
No, I think both of you and the other side has conceded that it has a construction component in it.
It is.
So we say it was for both construction goods and services. So is it 20% that is applicable, or 20 million? 20% or 20 million?
Yeah, it appears to me that it will be 15 million, but it appears to me that maybe the correct way will have to separate the construction component and the services component, because the construction component says 20 million and then the others says 15 million. And I haven't done that exercise, and it hasn't come to my mind until now. We are always under the impression that it is 15%.
Yeah, I think the 20 million is the one that is applicable, but well, subject to, you may have to submit something afterwards, both of you, on that. But I think the 20 million is the one that is applicable here.
Okay. Okay. We will take guidance from the court. Yes. But taking into account that when we raised the issue of CIBD, the defense was always that construction was by the way here. But the fact of the matter is construction is there. So the percentage that the construction took from the money that we are talking about, maybe we need to do some more work. We'll take guidance from you, my lord.
Is there any evidence that this was legitimately extended?
I beg your pardon, my lord?
Is there any evidence that the extension of the contract to bring in Bethlehem was legitimately extended? The contract, in other words.
Oh,
how was it extended?
Yes, my lord, there is a long annexure 56 there. JN 56.
Yeah, so you see, by the way, I must just say here, all my extensions are in, but the annexures are in PDF. So I would not have read all the annexures because they are in PDF. So I would have read everything that was sent to me in Word. So don't be surprised when I am ignorant of the contents of some of the annexures. I may have to get someone to convert them. So that's my predicament.
Yes. No, it's understandable. I'm just trying to answer my lord's question.
Yes.
So a question was asked. When I started by saying long, the answer might be long, but there was no procedure followed here. So the question was asked and it was responded to by Mr. Matlachi, the HOD, in 2023.
Oh yes, I remember when he said he was nothing. There was no meeting with him, that he knew nothing about it.
Yes.
So is that the answer?
His response was, as the accounting officer, I was not approved or allowed the variation where the scope of the contract was increased or expanded through an additional helicopter. This matter was never discussed with nor brought to my attention by anyone in the department. This matter was never discussed nor approved in any meeting I attended. And point number 3, he says, attached, please find a copy of the affidavit of Mrs. C.E. Devet, an official of the Free State Department of Health, indicating how has the process unfolded until the second helicopter was allegedly added. See annexure F. The reason I said it was a long answer is there is this annexure attached where Mrs. Devet says something in her affidavit. And the long answer is
I have not seen that affidavit. I don't think it's part of my papers.
It is a one-page affidavit. If I find it, I will put it.
No, I understand, but I don't have it. It wasn't provided to me. It's not amongst the papers that I have. Look, for the respondent, for example, I only have the answering affidavit. Am I right?
For the respondents?
I mean, for the respondent, yes, I have. Yeah, it's the answering affidavit and heads. And I'm not even sure whether I have. Maybe I should get onto that exercise now, because I may find my. Just a second. Okay, supplementary affidavit, authorities, answering affidavit and heads. That's from the respondent, first respondent. Then from you, probably it's your answer to the application to file a supplementary affidavit, founding affidavit, heads of argument, applying affidavit, no annexures whatsoever, nothing in from both. So all the annexes to which you've been referring me, I don't have.
Oh.
And maybe perhaps we should go into that exercise. Whatever annexes you think are very critical to this matter, if you could please send them. And Ms. Killian, I invite you to do the same. If you could just come together and see what is it that I need to have to properly assess this matter.
Thank you, my lord, for the invitation. However, I think what the tribunal is searching for now is like a confirmatory affidavit. I don't think that is what my learned friend submitted. There are in the annexures attached to the founding affidavit and affidavit, and I think that's maybe where the confusion lies at this very point in time.
Yes, but even see the affidavit that is sent to me electronically, you would appreciate that I read. I use a voice synthesized computer, so yes, the annexures would be in a separate folder.
I understand.
So whilst reading the founding affidavit, if I think an annexure is important to read, I would go to the annexure folder and then pick it up. Yeah, so I won't have any annexures attached to the affidavits. So you can just, as I say, perhaps you should come together and see which of the annexures are important for the tribunal to have.
Thank you for the invitation.
Or just send all of them. Yeah, okay.
We will do that. Thank you.
Thank you.
Yeah. Okay. Thank you, my lord. Yes, the affidavit that I was going to, it's one page. I was going to read only one paragraph, but
yes, that's fine.
My attorney is listening to the request by the tribunal, and the message that I get is that the annexures were sent via courier, but I'm sure she has heard what is required, and then we will take it from there.
So are they here with us, but just that they were not converted? Is that what is that
yes. If they were sent by courier, I don't think they were. The annexures are in PDF, as my lord has correctly said. So they were not.
Just a second there, Mr. Chilwan.
Yes, Judge.
You have the annexures in this matter?
Yes, we do, Judge.
You do?
We do have the hard copies. Yes.
Oh, good. Okay, but then don't worry. Okay, thanks. Okay.
Okay.
Don't worry. I'll make sure that they get converted.
Okay. No, thank you.
So I just asked you to meet and see. But it means I've got access. It's just that they are not in the right this thing, in the correct format. Yeah, but yeah. I'll make sure.
No, it's understandable. Okay. Okay, just to answer my lord's question, I've read the response by the HOD, and he has attached an annexure by a lady, Katharina Devet. It's a one-page affidavit, half a page affidavit. She says, I, Katharina Elizabeth Devet, in brackets Kana, that ID number, senior supply chain practitioner at Emergency Medical Services, declare under oath the following. She defines the contract. I'll jump that, and this is the paragraph I want to read. An order was issued for hiring one helicopter, but Mr. Ruben Reiters, operational manager, and Mr. Sipo Toa, control center manager, discussed the hiring of a second helicopter, with Patricia Hose, assistant manager at Big Management, during the week of 19 to 23 December 2016. Next paragraph. After a few telephonically discussions with Patricia, she confirmed that the contract make provision for the hiring of more than one helicopter, and the process can be started to issue an order for the second helicopter for the Bethlehem area. The last paragraph, the file was open and order, that's the order number, was issued on 23 December 2016 for hiring of a second helicopter. So to answer my lord's question, in short, is that there was no proper process for the extension to hire a second helicopter.
Right.
Yes. The issue about overcharging, there is an issue about an interpretation of at what stage should the rates change. And our vision is that the first 3 months, which is called setup, it is the setup means that those hangars would have been set up. But if no hangars have been built then and completed, then they cannot go into now charging the rate as if they are now operating as if the hangars are there. So what we complain of is that although the contract says within 3 months of setup, there would have been I mean, the hangars would have been completed and they would have been allowed to charge. So what we say in paragraph 191 of the founding affidavit is that as at December 2016, Halo had not completely met the setup phase requirements, that being the completion of the construction of an aircraft hangar, helipads, and the upgrades. Hence, we say they were not allowed to charge the higher rate, which the contract says 3 months, although it says 3 months, but the qualification is that they should have finished the setup. So the setup was not finished. That is where there's an issue about
do we have a rate applicable prior to the to the completion of? So are you saying before completion or regardless of whether construction had commenced or not, they were not allowed to charge that rate?
Yes, the agreement all along was that the setup will take 3 months. I mean, that is the interpretation that we need to give to this.
The setup of the hangar and helipad?
Yes.
Or generally?
Yes, when we say the setup, if I may go to those periods that they've given us, the setup was understood to be the completion of the hangar, the helipads, and the upgrades to where they did not need to create a new helipads. So
okay, let me just understand this. You're saying the 3 months was supposed to be just supposed to be a rate prior to the completion of the construction of the hangar and helipad.
Yes.
After 3 months, it assumes that a hangar and helipad are there or were there.
Yes.
Okay.
So that is the interpretation that we say is correct, and we would like the tribunal to conclude that. So the conflicting interpretation is that 3 months is 3 months, whether they are finished or not. We submit that cannot be. Then the last point.
I see. So I see someone is sending messages here. I think that can't. Yeah, don't do that, please. Whoever is posting messages, because she or he says, yes, that is how we have calculated. We have a setup rate, and that is how we have. Who sent that?
Oh, my apologies, my lord. It is my attorney. She was supposed to send them to me privately. My apologies to that.
But now she sent it to everyone. That's not a it's not in order. Eh?
Yes, she is listening. She will send to me privately. I apologize. Yes.
Thank you.
The last issue, I've reached the end. The last issue is the issue of the Phumelelo judgment. I agree with my colleague, but the Phumelelo judgment did not really bring something new, because the court or the tribunal always retained a discretion of what to do with the profit or with the money paid after it has ruled on the legality or otherwise of the contract. So the Phumelelo corrected some of the misinterpretation, but we know even from the Gijima versus Sita matter that even in that matter, although the contract was found to be invalid, the court still exercised a discretion and did not divest Gijima of whatever proceeds of the contract. So what we are saying is that you still retain a discretion whether or not to divest the profit from the respondents. And the order that we're seeking in paragraph 5 clearly says that if we are successful and in the just and equitable remedy which we submit that they are not entitled to be benefiting from this contract, my lord should exercise his discretion on the facts of the case. And one of the issues that we can just highlight is
just Mr. Mjapil, let's just pause here just for a second. I think we need a comfort break, a short comfort break. I'll be with you in a minute. Just a second.
As the court pleases.
Yes, I'm back. Mr. Mjapil, you may proceed. You are almost at the end.
Yes, I'm almost at the end. Yes, I agree with the submission made by my colleague about the Phumelelo case. But we've never said you do not retain a discretion whether or not to divest or to allow the so-called innocent third party to retain the proceeds of the contract. But what we are saying is that taking into account the facts of this case, and some of the facts which of this case, although it's so unfortunate because we did not receive any response from the department, but we've made these allegations, and in the morning I've stressed on the fact that it does appear from the records that we have, and we said it in the founding affidavit and no response was given, that the record shows that only 2 bidders bid here, and the 2 bidders is the first respondent and VUSA. At a later stage, we suddenly find that there is a third party that is supposed to be part of the JV.
What's your submission on that? Because I know that you made that point, and even
Yes.
in the founding affidavit in Hayes.
Yes.
But what are you saying about it?
What we are saying about it, and I qualify it by saying, unfortunately, we did not get a response from either the first respondent and the department. All what is that it does appear that the the respondent would be a party to a later edition of BUTHELEZI, who was not recorded, especially by the TEC, as a part of those people that tendered. So in as much as we assess whether or not they are innocent third parties, that fact cannot be wished away. All they tell us in the supplementary affidavit is that they don't tell us that they bid together with BUTHELEZI, because that is the question that is in the answering affidavit. I mean, in the founding affidavit. When they file their further supplementary affidavit, they just complain about that BUTHELEZI did not contribute anything in terms of work. But that question still remains unanswered. And I can take it only up to there because we also don't have a register of who bid. But the TEC tells us, the TEC technical evaluation.
BUTHELEZI was not one of the 9.
BUTHELEZI was one. Yes, it was one of the 9.
It was.
Yes. And this is it was one of the 9 and also one of the 4 that bought the document. Then buying the document, attending the compulsory meeting and buying the document does not necessarily mean that the document will be completed and returned. We don't have the register of who submitted by the closing date. All we have is the TEC that tells us 2 bidders. Yeah. And they don't mention BUTHELEZI. I mean, when BUTHELEZI is mentioned for the first time, and we said it in our heads, there is also a discrepancy about the description of BUTHELEZI by the 2 evaluators who were part of the BEC. So that answer, we don't have it, and our submission today will be, it needs to be taken into account to assess as one of those parts that the court, I mean, the tribunal has a discretion of whether of the just and equitable remedy.
What is it that I must take into account insofar as BUTHELEZI is concerned? Because it's a JV, isn't it? So whatever Halo is not alone.
Yes.
The order that you're asking, the parties who are cited, it's a JV, not Halo, not Halo.
Yes.
Am I right?
Yes. The contract was awarded to a JV.
Yes. So the order can't be in the name of Helicopter Aviation alone, but it will be the JV.
Yes, my lord, our submission is that, remember, the JV is not a legal person. That is why when court proceedings are instituted, they have to be cited separately. But the JV is a partnership that that is alleged to have been done. But the funny thing in this matter is that the JV is only identified at the second stage of the evaluation, not at the first stage of the evaluation. At the first stage of the evaluation, we found only Halo. And we also found the weights. Only 2 bidders bid, and then they mentioned them. Then the contradiction comes when we get to I can only take it up to that stage.
Okay.
Yeah.
Is that all?
Yes, that is all. I beg your pardon, my lord, just one discussion. Yes. Okay, thanks for the indulgence, my lord. Those are our submissions.
Okay, just I may be departing from convention here. Just to finalize, is there anything that was new, Ms. Killian, that you'd like to address? In which case, if you do, I'll again conclude by referring to Mr. Mujapi, if you do take up something.
I'm not going to take up the offer, and I'm not going to lengthen the proceedings. Thank you for the invitation.
Yes, thank you. All right, thank you. So that concludes the proceedings then, am I right?
Yes.
Good. Then judgment Yeah, judgment is reserved. I'll endeavor to hand it down before 3 months.
As the court pleases.
May it please
Thank
the tribunal.
Thank you. Thank you very much for your argument. It really assisted me. The only disadvantage is that, as I said, I didn't have the annexures, but I think you did your best to make me understand what is going on. Thank you. For tribunal agents.
Thank you.
Thank you.
you.